All right, Dean, thank you very much for showing up today and showing up on our podcast. We really appreciate you coming here. So I got a few questions for you that you could pretty much help us shine some light to with your years of experience. So my first question actually is like, how long have you been practicing, like injury PI cases?
Well, I've actually been practicing for nearly 50 years.
Oh,
I
wow.
started as a law clerk in a law firm in 1974. I graduated from law school in 1976.
Mhm.
And even during that time as a law clerk, I practiced with the partners in that firm until I became a partner, and of course was an associate for years
Right.
in the personal injury area.
Wow, that's really, really nice. You've got a wealth of experience. All right,
Well,
cool.
yes.
Yeah. All right. So my first question for you here is that what types of personal injury cases do you specialize in, and how much experience do you have in handling them?
Well, I have a broad range of experience. The primary personal injury cases, of course, arise out of motor vehicle collisions. You'll notice I never call them accidents. In my world, there are no accidents.
Right.
Collisions occur because somebody was doing something wrong.
Right.
That's one of the primary areas. Then, of course, there are many other areas too. In law school, for example, we always talk about slip and fall cases. I don't like that term. I call them fall down cases. Those are cases where someone fell for a reason that was outside of their control. Okay? So there are injuries that occur there. Then you have cases where a person goes in for medical treatment, and we commonly refer to those
Yeah.
as medical malpractice cases. I like to simply call them medical negligence cases, where the doctor has either done something wrong or failed to do something properly, or admitted to do something that they should have done. And then we also have products that are put on the market that end up being dangerous. The reason you wore a seatbelt in your car today when you drove to work is because trial lawyers filed lawsuits compelling motor vehicle manufacturers to put in seatbelts. They would have never done it because it was costly if they had been compelled by lawsuits that proved that it was safer to operate a vehicle and have it in a collision if you
Right.
had seatbelts. And also the same way with airbags and many of the other roll cage features and things that you see on automobiles now that you did not see in the past, that have brought the vehicles to be safer. So a faulty product is certainly another area. And then, of course, you have the whole area of medications that have very serious side effects. And that's another series of cases where people receive personal injuries. Or, as we know, in the United States, 7% of medical errors, negligence, are caused by the administration of the improper medication. So even though the medication itself may not be faulty, it was administered improperly. And then, of course, you have finally, and certainly this is no particular order, injuries that occur at the workplace. Those are commonly referred as worker compensation injuries, and I've handled those kind of injuries as well.
Wow, that's a lot there. You're stacked. So now, can you explain the typical process involved in pursuing a personal injury claim from the initial
Yeah,
consultation to resolution?
I certainly can. It's a rather lengthy process, particularly if you get involved in the filing of a lawsuit to recover because it could not be resolved prior to settlement, which we all tried to do, but rarely does that always work. They had about 90% of all cases settled before trial, however, because by then everybody has gone through a process called discovery, and they know everything that everybody's going to say and testify to. But initially, it's really to make it as easy as possible for the average person.
Mhm.
It's really a two-step process. The first step and most important step is liability. Did someone do something that caused another person to be injured that they could have avoided because the person at fault, our system is based on fault, or someone does something wrong? And again, motor vehicle collisions are the best example. Someone ran a red light and T-boned somebody in an intersection. They're at fault. So the first thing you do is step number one is make sure that you can establish that the person who caused the injury is more at fault than the person who was injured, because in most states you have what's called comparative fault. So they compare the fault of one person to the other person. In my example of running the red light, person who was hit and their vehicle might have been speeding. Well, did that really contribute to them getting hit? Probably not. But the defendants will always bring that up as a possible causation. So that's the first step. And of course, if you're involved in a thing like that and you have a phone and it has a camera, you should take pictures of everybody and everything in the scene. But sometimes you don't have that luxury. If you're seriously injured, the ambulance comes and takes you to the hospital and you don't have an opportunity to take pictures then. But later, while you're being treated and in the hospital, it's always useful to have pictures then to establish your treatment. And that leads us to the second step, which is, what are your damages? How badly are you injured? Is it going to just be what we call acute, which means it can be treated and you will heal up from it? Or is it going to be chronic, where you're going to have a problem and permanent injury for the rest of your life? And so that's really kind of the two-step process that we talk about with our clients from the very beginning. And then, of course, once you file a lawsuit because you couldn't get it resolved, which is usually with an insurance carrier, obviously, in the motor vehicle context. If you can't get to a settlement, then you have to file a lawsuit and you get mired down with all of the paperwork that goes back and forth, and then depositions under oath of witnesses, including your experts that say what really happened. And it goes all the way then through that very lengthy process. Can be a year, can be 2 years, can go much longer sometimes, until you actually get to stand up in front of a jury, as I have done over my career, and get to say, members of the jury, wait till you hear what happened this time. And you get to explain it to everybody.
Right.
So it can be very lengthy. I think most people are reluctant to go to court, but sometimes you just have to, because you can't resolve it, or the injuries are so grievous that the insurance carrier won't accept the responsibility and pay something fair. Now, during that process, we also sometimes engage in mediation, where each side shows up and we have a neutral party go back and forth and try and resolve the case. And mediation can be useful in some cases.
Nice. That is very, very, that is extremely informative for us here. So now the next question I have for you here is that, like, what criteria should you or should someone consider when selecting a personal injury attorney to handle their own case?
Well, I'm going to show you that I have a little bias, and I admit to the bias. The lawyers that advertise, apparently they have to get business. I don't have a website. I've never ran an ad. I never will. And I may never get a website, although many people tell me I should. I don't have to, because my business comes to me in the best way, which is by referral, either by judges, lawyers, or usually clients that I've done work for who were pleased and come back to me. So therein lies my prejudice, my bias, which is that I would be very careful not to just hire a lawyer just because I saw his ad on television or heard on the radio or that sort of thing, or saw it in the newspaper. I think that it's more important for a person to select a lawyer by talking perhaps to other people and other friends in their community about maybe lawyers that they have used, and get referrals and talk to them about how satisfied they were with that lawyer. And the results are always important. We know, having done studies on this, that clients are most impressed, and the most important thing to them is effort. They want to know that the lawyer worked hard for them. They realize that as lawyers, we don't control the result at all. We wish we did. We'd like to believe we were in control and got the result every time we wanted. It doesn't happen. But we are good at gathering the evidence, getting the case ready, making the best presentation for the client possible, and hopefully resolve it that way. So my advice, I know it's a long answer, is
No
yeah,
problem.
you can look at those ads, but I think you're better off if you check with other people that maybe have had a situation where they had to consult with a lawyer. And also, if they happen to know anybody who's part of the courthouse or people that have worked in the legal profession. I think they know who has done a good job and who works hard. And I say this all the time, and it really is true. If you talk to your doctors and you say, I need a doctor for a certain thing, the doctor sometimes will say to you, well, whatever you do, don't go to that guy or that guy. So
Right.
that's sort of code for, no, find somebody else. And sometimes I'll make a recommendation. But I really think that talking to judges, talking to people that have experienced something similar,
Right.
that's the best way to do it. And then go and interview them yourself. And if you're dissatisfied, don't feel any obligation. Go find somebody else. Now, I'm not saying all the lawyers that advertise shouldn't get the business, but I think you need to be a little more comfortable about who you pick than just instead
Of
of you
course.
spending money on an advertising.
Of course. Of course. It should be based on merit, basically, what you've done and, results.
Well, yes, and again, someone that will work hard and do the best job for you. We don't control the outset. Anybody who claims to be a trial lawyer, let me put it that way, it's not Perry Mason who wins every time. In
Right.
my business, if you haven't lost a case that you thought you took and could win, then you've never tried a case. There are
Mm,
just some cases that turn out and you don't get the results you want. And
mm.
certainly, if you go to a lawyer who promises you a result, find a different lawyer.
I'm with you on that. All right. So now, through your experience and through the years of being a lawyer, being an attorney, like how do you assess the strength of a personal injury case, and what factors contribute to the successful outcome?
Well, what I prefer to have happen is I like to have the people come to me as soon after their injury as possible,
Mm.
because every case and in every jurisdiction has a different statute of limitations. And I don't want them to come to me just weeks, days, months before the statute. I'd like to get it early on where the evidence is still fresh. Okay.
Mm.
And because I've been around long enough and I have a lot of recognition in the community, I do get those phone calls. Hey, my wife, my brother, my uncle, my mother, where somebody was
Mm.
injured yesterday. We'd like to come see you about it. Those are my preferences,
Mm.
because then you can immediately start assessing the case. And again, I go back to my simple two-step process. How is liability? Is the liability good? Okay, then let's look at how seriously the person is injured. And lots of times early on when they come to you, you don't know how serious the injuries are going to be. So you need to focus to establish who is really at fault, who really caused this. And then you can always look at the damages later as the person hopefully heals up.
All right. Good. That's an excellent answer. So now, can you provide examples of challenging personal injury cases you've handled and strategies you employed to actually overcome these obstacles while running this case here?
Yes, and if you don't mind, I'll back up a moment to what I was just talking about. I had a gentleman come in, and his wife had passed away, and his daughter was with him, and she was a nurse. So she was well versed in the medical process and what had happened with her mother. And her mother had gone in for some treatment to one of the local hospitals. And during that time, they failed to give her any diuretics, and she ended up retaining way too much fluid and died of congestive heart failure within a week,
Oh,
which
wow.
is very serious and very obvious, frankly, medical negligence case. But here was the problem. The lady had cancer, and that was the reason she went in for these treatments. And the doctor had already told her, well, you probably only got about 6 months to live.
Mm.
Now, between you and me, if a doctor says you've got 6 months to live, they really mean you've only got about 2 months. They
Oh,
always
wow.
seem something magical about the number 6 months seems to be just far enough out there that you
Right.
don't immediately worry, but yet it's clear that you are terminal. So the problem with that case was not liability. It was really, I thought, fairly obvious and clear, and I could prove that in court if necessary. But what are the damages? You have a lady that was already given the word medically that she was going to pass away sometime within that time period. So for that reason, I declined to take the case. So that kind of explains that. But the factors in determining the case are, first of all, again, do you have good liabilities so that you can establish that it wasn't your client's fault
Mhm.
that caused their injury? And second of all, how serious are the damages?
All
Now,
right.
the obstacles, of course, are many.
Mhm.
Litigation is very expensive. And going to the medical negligence case, for example, or even the motor vehicle collision case, we end up having to hire experts lots of times who are very expensive. That's a whole cottage industry of people
Mhm.
that testify as experts within very unique, specialized fields. They're very expensive. In a study we did, the study's probably 25 years old now, so I haven't updated it. But the average cost of a medical negligence case to prepare it in the United States was $50,000. And you have to remember, we take those cases on a contingent fee, meaning that if we don't win, nobody gets paid. If the
Mm.
jury doesn't give you a verdict, or if you don't get it settled, the lawyer doesn't get paid, and certainly the client doesn't get paid. And you've expended all those costs. So it's very high risk, and I'm sure that those costs have gone up astronomically since that study was done. I haven't seen a recent one. So
Right.
there is the main obstacle with a lot of cases, even in a motor vehicle case, is that sometimes you have to hire an expert if there's a question about, well, was the light really red, or who was really speeding, or that sort of thing.
Mm.
And the expert then comes in, studies all the data about the collision, and then gives an opinion as to who was at fault. And again, you have to pay them to do that because they're objective. Now, we say they're objective, you understand, but everybody can shop for experts who will say, back up their case. I don't like those kind of experts. I think they show up and look poor to the jury. I want someone that tells it honestly what they believe occurred.
Mm.
Okay. And that's really an important part of the whole process, and also a very expensive part of the whole process.
Right. Wow, that is really awesome. So now, like, what role for you personally, in your experience, what role does evidence play in personal injury case, and how can an individual strengthen their claims by preserving and presenting evidence?
Well, the first thing that anybody should do when they're injured, or when they have someone they know that's injured that they're helping out, as I said, try and take pictures of just everything that might be part of the case. You don't have to self-edit. Just take pictures of everything. Motor vehicle collisions, being in the hospital, before and after pictures if you go into for treatment and think it went the wrong way. All of that is very useful, as the lawyers can sort through it because you preserved it. And certainly the other thing that you want to do if you're the injured party is to keep all of your medical bills, in particular your EOBs, explanation of benefits. If you have health insurance or some coverage, you want to make sure that you know exactly what the total bills are that are related to your injury, as well as what maybe your other insurance paid. And there's a whole sub area of subrogation that we won't get into here, where you have to pay back your health insurance provider for what they've paid out. So again, knowing who you might have for witnesses, getting their names, addresses, pictures of them, so you know exactly who you're talking to.
Mhm.
Again, in a motor vehicle collision, if you're capable of doing it. But really try and just gather as much of that information that is easy to gather
Right.
before you go see the lawyer.
All right. I mean, that makes
And,
total sense. Yep.
yeah, and then let the lawyer and his staff sort out what's going to be relevant or not, and then also let them go obtain any other information that they think they will need to prepare your case, your claim.
Mm. All right. So now, how do you determine the value of a personal injury claim, and what factors are taken into consideration when calculating the damages? In from your experience, of course.
Well, yes. And every state um, can have different things that you're allowed to be compensated for. Okay. And generally, if you're injured, saying again, we'll go back to the typical automobile collision case,
Right.
and you lose time from work. Well, you lost wages, for example. You should be compensated for those. But also, in addition to that, states generally allow what we call hedonistic damages, which are loss of any function of the body, but certainly past, present, and future pain and suffering are elements. These are called non-economic losses. Certainly, lack and loss of function is a problem. If, for example, you were in a collision and your arm no longer functioned properly, and you lost grip strength, and you could hold on to things, or paralysis is probably the easiest example, where you become a paraplegic or quadriplegic. Those are catastrophic injuries.
Right.
So we have to try, and there's no magic formula for this at all. I wish I had one, to determine what a case might potentially be worth. Part of it is the experience that your counsel, in my case, me,
Hmm.
has with cases similar with similar injuries. And if you have a lot of those different kinds of cases over the years, you have some sense of what they might be worth, adjusted for the present worth of what they might be worth. A case 20 years ago might be worth X amount, but today it might be worth more because of the economy and the cost of living and things that's increased. So you have to take all of those into consideration. And again, sadly, going back to the case I told you about the lady who was going to pass away,
Right.
certainly her life had a lot of value from the standpoint of losing those last number of months of her life. And yet it's hard to get a jury or an insurance carrier to put a number on that. So you have to sort of furnish a number for them and hope that they feel that they're comfortable with that number.
Mm.
But that's one of the things we assess is what is, if you have good liability, okay, let's assume that. What is the nature of the injury? Is it, again, chronic and going to last for the rest of their life or not? And
Mm.
certainly with the loss of an arm or a leg or paralysis, and what we see so often now are traumatic brain injuries, where someone's head is slammed against the windshield or slammed against the side of the car, um, or in a fall down case,
Mhm.
they've fallen and hit their head. I am involved right now in a case where a gentleman went outside, and as you could appreciate, here in the Midwest, we get terrible winters with ice and whatnot. And at the apartment complex, they did not clear the ice for him, and he had no real choice. He only had one door he could exit, and it was necessary for him to leave, and he fell on the ice, hit his head, and died about 3 days later.
Oh.
So that's a very serious situation, and of course, you have to establish the damages are fairly obvious there. It's a matter of valuing that person, but you still have to establish that the apartment complex failed to do what they should have, which was to clear the sidewalks.
Right.
So a lot of factors go into assessing the value, but I would say, well, for example, for many years, and some insurance carriers and some insurance companies in particular still use a program called Colossus. And what it does is it takes you feed the data in on lost wages and medical bills and the age of the person and all these different factors, and then it spits out a number. And sadly, some insurance companies rely way too heavily on that number because every case is unique,
Right.
uh, you know, um, and it's hard to say that one size fits all in terms of a certain injury. It really doesn't. It depends on what that person's doing and what their capacities were. We see people well into their 80s and 90s who are highly functional,
Mm.
and you know, they're much more youthful than someone else of the same age. So if that person gets injured, excuse me, and their life expectancy is shortened, or they now can't do the things, and I'll use golf as an example, say they can't go play golf anymore. Well, what is that worth to them versus someone who perhaps wasn't playing golf anyhow? They've lost that functionality, and that's where these non-economic factors come into the change in the quality of their life. And so hard to put a number on those sometimes.
Mm.
That's why we hope juries can do it for us.
Oh, okay. All right.
But
So
it's
now,
also a difficult
uh-huh.
task for the jury to put that number, you know.
Right. All right. So now, like, in what situation might like alternative dispute resolution methods, such as mediation or arbitration, right, be more suitable?
Well,
Like
I
that.
think that it's
Right.
most useful in cases where there is a lot of disagreement over what the value of the case might be.
Mm.
Because sometimes the defendants have dug their heels in and just say, no, we just don't think it's worth that. But the plaintiffs say, no, you're not listening to us. We really think this individual is hurt, and you should compensate them accordingly because it's really has changed their life or has had affected them.
Mm.
And also as a plaintiff's lawyer, which I usually am, although I've been a defense lawyer, an insurance defense lawyer occasionally, um, cases that I think have weak liability or questionable liability, where a jury could potentially go either way. It's kind of nice to mediate them because then at least you've got the potential to get some kind of recovery for the injured party without taking the risk that a jury might give them nothing.
Right.
And from a defense standpoint, mediation's good because you've got certainly we're going to pay a certain amount, and we don't take the risk that a jury might make us pay more.
Mm.
So mediation has that value, but again, it all depends on which side of the case you're on and kind of some of the factors that go into it. But generally, we try to mediate all cases. And in California, for example, I was involved in a case a number of years ago, and I assume that hasn't changed.
Mm.
Um, Mediation is mandatory. So you file a personal injury case, and you have to at least attempt to mediate it before it ends up going all the way to trial.
Mm.
Sometimes that works well because people just agree on an amount that will be paid and the case is over, and that brings certainty to both sides. But I have some mixed emotions about mediation because as a plaintiff, I sometimes feel like my injured party is taking less than they might get. And sometimes that difference is important to whether their life is better afterwards or not.
Of course. Now, which leads me to the next question here, right? So, like how does the legal process for a personal injury case differ, like in like a public place, workplace, or a result of defective product? Like how does it differ in those situations?
I think the biggest difference is the cost in preparing the case from the plaintiff's standpoint.
Mm.
The motor vehicle collision case costs money, obviously, to prepare because you have to pay doctors to testify about the injuries. You may have to hire an expert to reconstruct the collision. And now with computers and graphics, it is incredible how there's actually companies that can graphically show you with the speeds of the vehicles and again, going back to my red light or speeding situation, exactly where the vehicles were. When they know where the vehicles ended up, see the skid marks, the point of impact, they know the speed limits, they know what the cars were doing. They can literally reconstruct what happened, which
Mm.
is just a phenomenal piece of evidence to show the jury. But again, that's very expensive. Now, relative to medical malpractice cases, again, you have to hire other doctors who come in and say this doctor did not do what they were supposed to do, or what they did do was wrong. And that costs. Product liability cases are also very expensive. And if you don't mind, I'll tell you about one that I had against General Motors a number of years ago.
Of course.
Back
Yeah,
in the
that'd be
80s.
amazing.
What happened in that particular case was a young man with a wife and 3 children had worked all day in his shop. He was a mechanic, and he drove a car to a local bar after work, and it was a cold, awfully cold January night here in the Midwest.
Mhm.
And he went inside in his coveralls, had a beer, nothing major. It certainly wasn't drunk, but he'd worked all day. And when he went out, he started the car that he had to warm it up, and he fell asleep. And the car caught on fire. And we were able to establish the car caught on fire because of a defect in the car relative to the catalytic converter. Okay. He was in the hospital in intensive care for 5 months before he eventually died. I left a widow and 3 kids. Now, as you can appreciate, that was a very serious injury, and certainly because he had surviving children who were minors and a wife, they all need to be compensated.
Right.
And I found an expert who, I actually had a couple experts, but one in particular I went to visit and talked to him, and I was looking at his resume, and I see here on your resume, doctor, he was a PhD in mechanical engineering. You'd worked for General Motors for 28 years. He said, yeah, that's right. I said, well, what'd you do for him? Well, I designed every part on a car. So he was eminently qualified.
Mm.
And I said, and then here I see after you left them and started teaching here at the university, engineering, you started work for this NASA, NASA, the space people? What did you do for them? And he said, I designed the brake system for the vehicle they drove on the moon. Now that is about as good an expert as you're ever going to get.
Yep.
And I couldn't wait to have him testify in front of the jury.
Mm.
So that's perhaps for me the most intriguing part about this business is I couldn't do a laminectomy. I'm not a doctor. I did go and audit gross anatomy at the medical school because I knew it would help in my personal injury practice, but I certainly couldn't do a laminectomy, but I think I could tell you if it was done incorrectly.
Mm.
And I didn't know anything about high power tension lines until I had a young boy climb up in an evergreen tree and get burned very badly by high power tension lines, and met experts there who told me what was done wrong with the installation and monitoring of those.
Mm.
So the nice thing about my work for me is that I get to meet all these people who are incredibly well educated, who study these different situations,
Mhm.
and who can render opinions and educate me on what I need to know to present the case.
Right. Well, that's an amazing example. The car one, and then which then leads me to the next thing here. Like, what advice do you have for individuals who have been involved in an accident, but they're unsure whether they have a valid personal injury claim?
I believe that everybody who has an injury should probably consult with an attorney. Routinely, plaintiffs' attorneys talk to people. There's no charge. They decide if they're going to take the case or not. The lawyer does.
Mhm.
But that will also help them get a half hour, an hour's worth of advice of that lawyer, and every lawyer can assess it differently, but that will help the person with his decision or her decision to pursue their claim. And usually the lawyer is happy to chat with them. And if the lawyer thinks that the claim is meritorious and worth economically the lawyer pursuing the claim, they'll tell him. And then the person can decide to hire them or not, or go get another opinion. Unlike physicians who occasionally get very upset about second opinions, lawyers are completely immune to that. We don't care. You can go talk to other lawyers all you want. We still will decide if we'll take your case or not. In point of fact, I used to go around the country with a doctor lawyer friend of mine and some other professors from Creighton and teach doctors at a day-long, 2-day seminar, actually, how to testify. Because doctors generally, although very good scientists and sometimes very well spoken, aren't particularly good at testifying because they don't really understand what it is they're being asked to talk about. And so we would go around and taught seminars all over the United States to doctors and nursing staff and hospital staff on how you should testify. First of all, testify honestly, but second of all, know what you're being asked to answer so that you will be prepared. And I think that was a very good thing for a lot of them because most of them were like the average person. They didn't want to testify. They didn't want to have to, and yet they were being forced to do it.
Interesting. Well, yeah, that is pretty much all the questions I have for you today. I really, really appreciate you answering them, and I believe our viewers here definitely have more to work with, and probably some of them would, haven't taken enough notes can probably lawyer up themselves. So, so
Well, I would like to, while I have you for a moment,
yes,
debunk some of the myths, because there are a lot of myths
of
about
course.
personal injury work. Okay. Back a number of years ago now, there was the myth about the McDonald's coffee cup case. For a long time, the insurance companies were promoting that as just an incredible injustice. So I looked the case up and I looked at what the result was. And here's what happened. All the insurance carriers and defense lawyers were telling the juries was, well, this woman spilled coffee on herself and got $2 million. Well, that's not true. There's a lot more to the story. What really happened was a lady went through the drive-through and the young girl handed out the coffee and accidentally spilled it in her lap. And the coffee was well over 180 some degrees in temperature.
Oh,
And
wow.
that particular location had been warned 12 times that morning that their coffee was too hot. And across the United States, prior to this happening,
Mhm.
all the McDonald's had been warned thousands of times that their coffee was too hot. And the lady's injuries were that she developed terrible infection around her private parts and on her legs,
Mhm.
and had to have medications every month to try and control these lifelong infections that she suffered from.
Mhm.
So the jury did render a verdict for $2 million, but the defense lawyers immediately filed a motion, we call it remittitor, and the judge reduced it to $400,000.
Mhm.
And then what happened was the McDonald's lawyer said, oh, that's still too much money, and took her up on appeal. And the case eventually did settle for an unknown number. But the problem with all of that is this lady had ongoing lifetime medical bills as a result of this. And the good result was that McDonald's reduced the coffee temperature that they were serving it at in an effort to make sure nobody else got hurt like that. Your washing machine for your dishes at home runs at about 140 degrees temperature, whereas this coffee was like 180 some degrees. So that's the rest of the story. And so that's one of the
Right.
many myths. And then there's always the myths about people doing silly things that if you really think about, well, nobody would be crazy enough to do that. And then there's always the delusion that there are, quote, frivolous lawsuits. Let me just for a moment dispel that myth.
Mm-hmm.
When you go see a lawyer, they go through the process I've talked about now. Is there liability? Is somebody else at fault that caused your injury? Or did you do something that caused your injury? All right. For example, let's go back to the gentleman that fell recently on the ice. If you go outside on your own walk and you're shoveling and you fall down because you didn't put down salt or remove the ice, that's your fault. It's somebody
Right.
else is in control of the property. Okay. So the myth is that lawyers just make these cases up and file them and ask for a bunch of money. And what you never get to hear is that a lot of those cases, if they can't prove liability, get dismissed by the judge, and then there's nothing, nobody got paid. So you got to understand that lawyers get paid on a contingent fee. Usually it's a third. Sometimes it can be more. Medical malpractice cases can be 40% or 50%. Depends on who's covering the costs. If the lawyer has to advance the costs, then obviously they need to be paid back. But if you take a case as a lawyer like that and you lose, you don't get paid.
Mm.
So the people that really monitor where the case has got any merit and should be filed are the lawyers. You're not going to stay in business very long as a lawyer if you keep taking cases that keep getting dismissed because you're not making any money. So when a case gets filed, there should, instead of being a presumption just because somebody said they were injured or said
Right.
that they think the case is frivolous, there should almost be a presumption quite different, that the good lawyer has looked it over and thought, yeah, this case needs to go forward. Because you don't file it and hope you're going to get paid. You have to be able to proceed and win or get a settlement in order to get your client any money, and certainly for a lawyer. And I think
Right.
that disperses a lot of these myths about people filing cases. I think you'll find, if you really track down those sorts of things in the newspaper, that someone filed it on their own, or they didn't have a lawyer that filed it, or if they did have a lawyer, there was some other element that made it that the insurance company or the newspapers weren't reporting, that made it more likely that it had some merit to it. Okay, because insurance companies in particular, and God bless them, we all need insurance. Buy insurance and get a lot of it. It's okay with me, because then if you injure somebody, they will be fairly compensated, hopefully, because you'll have enough coverage. Because I've had way too many cases. In fact, I just had one recently I settled where the lady's injuries were worth much more than the coverage, but all they did was just give us what coverage they had. So that's a problem too. But as I said, occasionally you got to understand the system. Insurance companies love it when there's a big verdict, because then they go out and scare everybody to buy more insurance. Oh, look at what happened in Oklahoma. You better get more insurance here in Minnesota, or
Right.
whatever. So as much as they despise those big verdicts, they like to broadcast them. And of course, those are usually a one-off deal, a very
Right.
unusual set of circumstances that resulted in what normally might have been just a simpler settlement got out of hand for some reason. So that's the first thing. And then, of course, the other thing, they like to make the public believe that lawyers just file any old case anytime they want. And now we don't, because we can't get paid if we do. So
Right.
those are some of the myths that go along with personal injuries that people need to be a little more
Aware of.
cautious of and aware of. Okay.
Right. hmm Yeah, definitely. I mean, that is one to note, because I'm sure this definitely gives more information to people out there to one, make sure that, okay, whenever you wanna get a lawyer, an injury attorney, you got to make sure, one, I mean, you're not like the actual cause of the thing itself. And yeah, so there's definitely that aspect of things, and obviously thinking that, oh yeah, it's a sure win or something like that. You gotta
Well,
bring it down back to.
going back to the lawyers that advertise, and I
Mm,
again, this is my bias. I pick on them. Uh, if you listen to the ads,
mm,
this is what they usually say.
mm.
If you've been seriously injured and it's not your fault, get a hold of us. Which means if you're seriously injured and
Mhm.
you is your fault, we don't want to talk to you because we know we can't win the case because that's the way the system works. So if
Mhm.
you watch the ads, you will see that's the gimmick, if you will.
Definitely, it
You know,
definitely is. Well, all
because
right. Well,
they take a lot of cold
uh-huh.
calls and have to do what I have to
Right.
do too, which is assess the merit. Is the case worth pursuing and financially, but also is it justified? And I think good lawyers, both good defense lawyers, and there are a lot of very good defense lawyers,
Mhm.
and a lot of very good plaintiffs lawyers, they assess these cases and they figure out whether or not this is really one that should be uh, should go forward or not.
Mm, that's right. And yeah, and the matter of ethics too. Being ethically, yeah,
Absolutely.
of
Yeah,
course.
you can't put forth an argument. Well, you've seen some of that in the papers recently where lawyers are being called to account for pursuing claims that were completely without merit, completely specious,
Mm,
without absolutely any proof. And then they
wow.
get disciplined and sometimes lose their law license or get suspended. And I'm perfectly in favor of that.
Of
You
course.
know,
Yeah, there needs to be a consequence.
there needs to
Definitely.
be consequences.
Yeah. Well, I really appreciate you again. And I hope to do this more with you, so we actually get more information and get people more information, more data, so they know, what is what basically, because you know, to avoid negligence and things of that nature, basically. So, yeah.
Absolutely. And I think um, the public really needs to be able to fairly assess what's
Hmm.
going on and not listen to the ads, not listen to the publicity, and not listen to the one-off uh, headline, you know, that sounds just outrageous until you really dig into what really did happen, and then all of a
Right.
sudden it becomes more obvious that there was something else that was going on there.
Mm. Yeah, that is true. Well, all right. Thank you very much. And this is pretty much it on this podcast. And I will see you on the next one.
Thank you. It's been a pleasure.
Absolutely.